Hey, Shira.
Hey, Yael, how you doing?
Good. How are you?
Once again, we meet.
Yes. So today we're going to talk about the first sale doctrine.
Indeed.
So maybe let's start with what is it? What's the first sale doctrine?
So it's exactly what it sounds. If you're a brand, you have control over the first sale of your item. Once you sold it, you can't control what happens or who sells it after the fact, and they don't need your permission to resell that item. Meaning you've benefited from your rights as the right owner when you received profits for the exact same item. I'm not talking about a copy or a recording, the actual physical Nike shoe. After you sold it and you received benefit and profits, Yael can go and resell it and does not need to ask Nike or I wish I was the owner of Nike, permission to resell this item.
Okay. So just so we're clear, I can sell any brand on Amazon without authorization, or should I ask Nike if it's okay to sell their product?
So the question is, what right are we looking at? If it's intellectual property rights, if it's trademark rights, they are exhausted after the first sale. So, with that question in mind, Nike can't. I don't need Nike's permission. I don't need to ask them. But there's always exceptions. We'll talk about the exceptions in a moment. But if it's the exact same product and it's just sitting on a shelf, and all I do, and I'm a conduit, I take it from the shelf and I sell it to the next party. Okay, I didn't do anything to it. Nike has no say. Nike sometimes tries, and a lot of brands try to circumvent this doctrine by either applying contractual rights, which if you're not a party to a contract, they can't really be enforced, but they try.
What type of contract?
For example, selective distribution. Okay? So Nike would say to Amazon, I don't know who Yael is. She's not one of my distributors. All my distributors are under contract. Okay? So because I didn't select Yael as a distributor, Amazon should remove them because I don't know who Yael is. Amazon does not enforce selective distribution in the States because it's a contractual issue. Think about it. Amazon is not looking to be in the middle of contractual fights and arguments. It's not their job. It depends on interpretation. It's going into all kinds of legal precedent. Amazon wants a clean mind, clean state, keep it simple. If it's a federal law, for example, trademarks, then they'll enforce it. If there's a federal exception, like first sale doctrine, they'll enforce it.
So for Nike, going back to Nike, just to make it clear, if I sell the Nike shoes in the US, okay, and I sell the real products that I bought from, one of the distributors in the US, and then I resell them on Amazon, Nike
has zero say.
Zero say.
However,
yes.
And here's the
however.
Yes, let's open the parentheses.
Always
exactly.
However.
However, Nike is still a force. So they can enforce it by having technical abilities, like they have brand registry. So they have control of the listing, and they can easily remove you from brand registry, or the simple fact that they have the control over the content sometimes would stop you from selling their brand or selling their product. For example, let's talk for a minute about the exceptions for this first sale doctrine, and that's how we'll circle back to this. Okay, so the first sale doctrine applies to the exact same product. Okay, if there is a material difference between the product that I purchased and gave money to the brand, and the product that in the condition and that I sell further on, it's not the same item anymore. And then the first sale doctrine, it cannot protect me. It doesn't apply.
What do you mean a difference in the condition?
Okay. So the classic situations are, I got a box of the Nike shoe and I decided to scratch off the serial number because I don't want it to be tracked or whatever godforsaken reason. I do something. I damage physically the box and I move it and I sell it forward. The product itself inside is still the same. I changed the box. I did something to it. I maimed the product. It's not the same product anymore.
Why would I change the box?
all kinds of, fell off a truck. I can't really prove that I sold it to the... you have to prove the chain of supply. You have to prove that the initial sale benefited the brand. Sometimes I can't prove that. I don't want to get into those issues. I'll just do something so it's harder to track or how to trace back. That would be obvious infringement.
Would that be because the seller who sold me the boxes doesn't want to be revealed or should not be selling it to me? Or
could very well be. There could be bazillion reasons. They are infringing on a distribution agreement, which we'll discuss again when we circle back to the selective distribution. That's another way. So usually in the beginning, when this first sale doctrine started to apply to trademarks, it's from the copyright world. When it started to apply to trademarks, and they were talking about differences or material difference, it was more about the physical item. But then once people caught on, the brands needed to find a way to fight back and still try to fight this first sale doctrine. So they added all kinds of services that are virtually part of the product. For example, warranty. They will not honor a warranty for a product if it wasn't purchased from an authorized distributor. And then since I'm not an authorized distributor, and I don't have to be an authorized distributor, but if I sell the item and that item doesn't come with a warranty, it's a different product. And because it's a different product, I cannot find refuge under the wing of the first sale doctrine. There's a lot of all these exceptions. It's an open list. It's not a closed list. They are they're a result of case law. And it depends on, it could be the same level of court, but in different jurisdictions. And different jurisdictions have different views or political views or whatever. They're more liberal, whatever. So sometimes you'll have one jurisdiction say that customer service that you say that is attached to a product means that if you don't have it, then it's a material difference. And the other would say, nah, the number's on the box. People can call in a customer service. That's not a material difference.
So in some states, you would get the brand would get that protection of the exception to the first sale doctrine, and in some cases they won't. So
absolutely.
So as a seller, it depends where you sell the price. So if you sell it on Amazon,
it depends on the jurisdiction of where you're being sued. Usually,
okay.
But there are defenses definitely because this is not cutthroat. This is not black and white.
Yeah.
Sometimes the material difference would apply, and sometimes the judge would think that it's not applicable. For example, quality control. Okay, that's another way brands try to circumvent the first sale doctrine. They say, yes, you sell my product. It is my product, but while it's in storage, okay, it's exposed to the elements. Rain, heat, whatever, it's inflating the package, I don't know what. When it gets to that buyer, to the end user buyer, then it's not the same condition. It's not this. It's different. It's a material difference, and therefore you don't have the first sale doctrine to protect you. And then the court says, and that's the majority of the case law. Again, there is contradicting case law on every exception, but the majority says it's not enough for you to claim that the quality is different. I can always say that. Okay. First of all, that needs to be proven with evidence, and it depends on the nature of your product. If I'm selling a pencil, it doesn't matter if it's exposed to the elements. It doesn't matter if it's at heat. It doesn't matter if it needs special, humidity or whatever. So it really depends on the product. And Amazon sellers, especially if they do FBA, have a great defense, which I use often in situations like that to combat these claims. The FBA storage facilities are in such high quality, they're probably on higher quality or at least the same level as any selective distribution of the brand, the way that they store the items. So they have to really work and prove or disprove the quality.
Right. So just to summarize this point, what you're saying is you can resell any brand. That's not trademark infringement because of the fair sale doctrine, because that brand has already sold once that product, and now you're allowed to resell it. So there's no infringement. You're reselling the real thing, right? The genuine products. So the fair sale doctrine protects you when you're reselling a brand, unless there's a material difference between the products that you're selling and the original product. And that material difference could be probably almost anything, okay? But there are ways, you're saying that there are ways to fight back and claim that, these material differences aren't really material.
Exactly.
And that's why you're allowed to resell. So you find yourself fighting against like law firms that claim that exception, and you claim that there's no exception to the fair sale doctrine, and the sellers are allowed to resell.
Right, because the brands, when they send a cease and desist, they'll assume certain things. They'll assume that it's not the same product because there's a material difference, or they'll assume first that it's a complete counterfeit because they haven't bothered to do a test buy and see that's their own product. And they just simply, they want to remove you. They don't like you that you're on the platform where they can't control you. They don't like that you're competing with them. And they want to minimize and want to control their brand and the distribution of their brand. Where does, for example, the technicality of brand registry come into play? There's an exception of the warranty that I mentioned before. So if I sell a phone cover and I write in the warranty of the phone cover on the product itself, I give a clear message before purchase, okay, to the buyers. This warranty will only apply if you can prove that you purchased from an authorized distributor. And I'm not an authorized distributor, okay? If I sell it on Amazon, and I have to, because the phone already exists, I have to add it to the listing that exists on Amazon, right? Because of the one listing per product policy. If I don't put in some sort of disclaimer on the listing saying this is purchased from a third party that and warranty may not apply, okay, then I would fall under the material difference. So if the material difference comes from confusion, okay, you need an educated buyer. If the buyer goes on Amazon and looks for this phone cover, and they see on the listing that there are all kinds of sellers, and it says on the listing itself that this is distributed by a third party that is not an authorized distributor of the brand, so take note that the warranty may not apply, then, and I still choose to buy it, there's no confusion, okay? I'm not, I'm completely aware of what I'm buying, and that disclaimer would serve to negate the exception to the exception, if you get what if you get what I mean. But then, if the brand controls the brand registry, and they control the content of that listing, they have zero incentive to put that warning on.
Of course.
Okay. There are templated warnings that Amazon puts on when they allow third parties to sell. So there's a question there if there's this 2-sentence language that is embedded in all Amazon listings that says that it could be by a third party and warranties may not apply. It's a question if that's enough, but at least it's an argument. Uh-huh. And if a brand uses warranty as their argument why you should stop selling, you can come back and say, here's a screenshot. It says this on there. It's an educated buyer that buys this and knows that the warranty is not there. I'm still selling the exact same item. And I have full right to do so.
But do sellers really fight that? I mean, if they get a letter from a large law
there's
firm,
one notorious law firm,
law firm that does that, they get the letter.
Which shall not be named.
They get the letter from that law firm. Do they really fight, or would they just stop selling that product and move on to the next brand that doesn't enforce the rights?
So there are a few things to consider here. One, if you're making a lot of money out of this product and that's your main income, fight. Fight, and it could be a hit or a miss. Often these brands, they just try to dilute at least the competitors. So they send out these cease and desist, and sometimes it hits, and people are intimidated and they leave it alone. And sometimes they they fight back. And it could be that if you fight back, then the brand is not really interested and starts in suing and going through litigation. It costs a fortune. Depends on what their budget is. Depends on what their incentive. It depends how big of a chunk of the sales you take from them. It could be they'll leave you alone.
Yeah.
Another,
like,
but
is it
another
like
thing to
chicken?
consider. Yeah, exactly. Another thing to consider is if it's not one of your main items, do you really want to start a fight with a brand? Do you really want to sell something where someone is objecting to it? Because, you don't want to make enemies. You just want to live your life, do your sales, your commerce, and be collegial as much as you can. So it really depends on your situation and can your business exist with or without it, and if it's worth putting, going all in.
Mm-hmm. And how does it work? Because you mentioned that's mostly in the U.S. You have that first sale doctrine, and you talked about selective distribution. How does it work in Europe? Is it different?
So in Europe, and partially in the States too, in a little caveat that I'll say in a moment, Amazon still only looks to enforce IP. They will not go into contractual disputes. It's not their place. But in Europe, the Supreme Court has decided that part of a brand's right in IP is its reputation. And in order to be able to enforce their reputation, they should control or have control and say who is selling their products and how the products are being treated. So in Europe, selective distribution is an IP right that has been ruled by the Supreme Court. So Amazon doesn't really have a choice. So they would enforce it if it was sold from outside the EEA. Mm-hmm. If it's within the EEA, then the first sale doctrine applies.
If it's sold outside of the EEA?
If it's sold from outside, it's imported into the EEA, then you need permission from the brand in order to import it into the EEA. If it's from within the different countries within the EEA, let's say Germany and I would say UK, but they're out. So
France,
Italy, or whatever, then they have no say. The first sale doctrine, which is in Europe called Doctrine of Exhaustion, applies. Their rights to control the first sale of that item are exhausted after they benefit from the first sale. But if it's from the outside, you need approval from the brand.
Okay, now speak English.
Okay.
Now I'm a seller. Can I sell brands in Europe or not?
Where are you located as a seller?
I'm a French seller. I want to sell Chanel.
Where?
In Germany.
If you're French and you want to sell in Germany and you source from Germany or France or anywhere else in the EEA, you do not have to ask Chanel's permission. You can go ahead and do it as long as it's the same exact item and you don't play around with it. Mm-hmm. If you are French and you're importing or you're sourcing from the U.S., then you'll have to ask Chanel's permission to sell it in the EEA on Amazon because it's part of their intellectual property rights. So it's not a contractual thing.
So it doesn't matter if I'm if I'm a selected distributor?
What do you mean by selected distributor?
You mentioned selective distribution. So it doesn't matter if I'm, if I'm a distributor that was allowed by the brand or not?
If you're an authorized distributor, then it depends on the contract. Authorized means that you have a contract with Chanel. And it could be that Chanel will constrict your ability to sell Chanel perfume to retail only and not sell online and give the online rights to someone else. That's the whole point. They control the distribution. They control the rights. They can nitpick and break down each right to bazillion licenses and profit as much as they can from each and every right that they have. And you would be contractually obligated, but Amazon would enforce it not because of your contractual ability, but rather because of the IP involved, which is the ability to control your reputation. Mm-hmm. Now, in the States, there are some exceptions to not applying for selective distribution. When it comes to luxury items, the courts have recognized the importance of controlling the chain of supply and controlling distribution to maintain the luxury aspect of your product. So some would claim in their letters that selective distribution does apply because of the nature of the item. And then you look at the item and you see it's a phone case. And then you say, give me a break.
Yeah. And how, so...
I just want to say one more thing about this law firm that must not be named. They often sue and get default judgments, meaning that no one actually defended themselves and they got a judgment against them. And they would sometimes quote and cite case law where they have won, but there's no one actually claiming anything against them. So, take with a grain of salt any cited case law that they provide in their letters. Often, if you go into it and you read it, there's so much to say about it. You can defend yourself.
So I want to talk about other types of, use of brands that are allowed. So when we're talking about my listing, I'm selling on Amazon.
Are you selling a Shira pen?
I'm not selling a Shira pen this time, although it's a great brand. I'm selling on Amazon. I have a nice listing, and I'm selling phone cases that are compatible with Samsung, or phone cases for my iPhone 14. Okay. Can I use the brand on my listing? Would that be considered allowed, or is that a trademark infringement?
Well, I'm so glad you asked. So the answer is, are you using this trademark for trademark purposes or as a description? Meaning, are you trying to benefit or gain from the reputation of that brand? So let's say I'm selling a case that fits Apple. What is the first word that I would use on my title? If I would say Shira phone cases compatible with Apple, Samsung, blah, 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 that's the first word on my title is my brand, okay? And at the end, it's a long list of brands that it looks like you're trying to describe the item. What's it good for, okay? If it's compatible with. You're not really trying to ride the wave and the benefit of the reputation of Apple or Samsung or, which other brand. That is allowed. It's called nominative fair use. It's another type of fair use that is special for trademarks. And you will have to, it's a judgment call. You have to be able to show that you're using it in a descriptive manner. So let's say on my website, okay, I sell Nespresso capsules. Nespresso fitted capsules under Shira. Okay. If you go into my website and the first thing you see is fits in small letters, Nespresso, huge letters, capsules by Shira, obviously I'm trying, your eye goes straight to Nespresso. So that wouldn't be nominative fair use. I'm not really trying to describe my product. Yes, my product fits Nespresso, but I'm trying to gain and enjoy the benefit of the word Nespresso. But if I say Shira in big letters, capsules for coffee machines, including fits, Nespresso, whatever, then it's in a descriptive manner. So use your common sense and evaluate it.
So using my brand first on the title would be would help.
It would help. It would help putting it in the throughout the description. You put it on the box and the images. Make it clear that what you're advertising is your trademark.
And are there specific words that you should use, like fits, compatible with?
Yes, exactly what you said. Fits, compatible with. For is questionable because it depends on if it's clear. When you say for something, it doesn't mean it's compatible with something. It really depends on the context. So you can use for, depending on maybe it converts better. I'm not a PPC expert, but I would use fit or compatible with just to make it very clear.
Is this the same on my website? If I have a Shopify website, is that the same, or is it only for Amazon?
The test is use your common sense. And if you just stand back and look at it and view it, and it looks to you as what pops out is the name of that trademark versus your product or whatever, then something's off,
So
you're exposed.
So the test is confusion of the customer.
Yeah, absolutely.
Perfect. Thank you. I think we covered most of our topics today. It was great. Thanks.
Thank you. Thank you.
Excited about that first podcast. If you have questions for our next podcast, feel free to send us messages on the comments of this video or send us email to the law firm. We'll be happy to add them to the topics of our next podcast.
Yeah, and I really enjoyed this. We should
you.
do this more often.
Yes. Thank you. Bye.
Bye.